Welcome, everybody, to this online only course on legal analysis. Um, Today, we'll be looking at how you can navigate legal judgments. The reason I created this video is because I have the impression that a lot of students feel overwhelmed when they have to read judgments. It's completely understandable because if you open up a judgment for the first time, it contains long paragraphs, long sentences, lots of technical terms, and it's usually quite a lot to read. Um, but before we move on to actually navigating through a legal judgment, legal analysis is a skill that matters because a lot of societal debates tend to find their way into a courtroom. Um, and if you want to know what's going on in those courtrooms, if you want to understand what the debate is about, legal analysis would be sort of an invaluable tool. Other than that, I think it's important because legal analysis teaches you a way of thinking that's primarily sort of analytical in the sense that we often have the impression that we reasoned our way into our beliefs. And when you use legal analysis in a systematic way, you learn to sort of analyze the arguments that have been given in a more technical and in a more sort of objective way before you come up with your counter arguments. I think this is an invaluable tool because it helps students in general to improve their writing, right? Because you might have a very strong opinion, but if you can't write it in a valid sort of argument form, then probably you're missing something. And this is something we'll come back to in one of the last videos on writing. But for now, I think the main focus is going to be, okay, so let's say that there is a judgment that you're interested in. What do you have to do? Now, the first piece of advice I would give my students would be to read a judgment and to try to dissect the sort of FIRAC structure behind the judgment. So FIRAC is essentially a structure that you'll see in a lot of judgments. It's not used universally, but most of the elements will still be included in the judgments that you'll read. So quite simply, if you look at all of these letters, we'll go through them. At the start of each judgment, you'll usually find a summary of the facts. And essentially, the purpose of these paragraphs is to explain to the reader how these parties ended up in court, right? So what did they do? What wrongs did they do to each other to end up in court? What other courts did they go through? Basically, just a summary of what happened before this judgment. And then the next step in most judgments is the court actually clarifying what the question is that they will be answering, right? So what's still up for debate? And the beautiful thing about that structure is all of the things that are included in the facts segment are usually not debated between the parties because that's the section that's left for the court, right? So if you agree that I, for instance, punched you in the face, there is no reason for us to have the court decide on whether that happened or not. So the things that are still left up for debate will be very neatly summarized in most cases by the judges themselves. Then the judges will often identify the rules that they will be using. And this happens usually in quite a brief manner. So the judges will just say, okay, we're going to use these specific rules to look at the issue. Then those rules, they'll often not be entirely clear, right? So not every term that is included in the specific law or in a specific bit of jurisprudence will tell you exactly what it means from the legal article. So the judges will add a little bit of an analysis of those specific rules and fill in the gaps, right? So what does this rule actually mean? That's what they would be doing there. When it comes to the application, there is usually sort of a translation from the sort of abstract rule to the concrete scenario, right? So in this case, if there is a rule that says you're not allowed to fight with each other, right? Then the court could say, okay, this was definitely a fight because the other person was bleeding in this case. So that rule was violated. So it's sort of a translation to the concrete facts of the case. And then at the very end of the judgment, you'll usually find a conclusion. So yes, you fought, you punched each other at the same time. So what should happen, right? Do you have to pay each other some sort of compensation? Should you just apologize to each other? The judges will decide in their conclusion what actually needs to happen next. Now, in order to make all of this sort of easy for you to understand, we'll use the Achbita versus G4S case as an example. In this case, there was a woman who worked in Belgium. One day she decided that she'd like to wear a headscarf to work. G4S did not like that, so they came up with a rule saying, okay, nobody is allowed to have any sort of religious or philosophical signs, and nobody will be allowed to wear religious or philosophical signs to work. She obviously was quite upset about it. She decided to go to court because she wasn't allowed to wear her headscarf to work, and they threatened to fire her. And then the court eventually decided that companies are allowed to project an image of neutrality, but that the Belgian court should decide whether or not this was in violation of the prohibition on non-discrimination. So if you've decided to use the FIRAC model, the first obstacle that will come your way is distinguishing between what's considered to be sort of contentious and uncontentious. And a good way to navigate that difference is to look at whether you're looking at an argument or an explanation. This is sort of a difficult task in most cases, especially if you're looking at really long technical paragraphs. But essentially, the distinction that you're looking for is whether you're being given a reason to accept a certain position or whether somebody's trying to explain to you what the underlying cause is of a certain phenomenon. So if we look at these two sentences, the first sentence says, states should open their borders because doing so improves the economy in the long run. And if we look at the second sentence, which is very similar, the economy has improved in the past few years because states have opened their borders. Now, in the first example, you're being given a reason to accept the claim that states should open their borders, right? In the second example, it's simply assumed that you believe that the economy has improved and that the underlying cause for that is that states have opened their borders. Now, when you're reading judgments, it's really important for you to know where you're reading an explanation and where you're actually being given reasons for a certain interpretation of a rule. Thankfully, there is another way to recognize arguments. So it helps if you understand what an argument actually is and what it is that you would be looking for when you're looking for arguments, because it usually means that you've arrived at sort of the contentious section of a judgment. So an argument is basically a collection of propositions that purportedly support each other. Now, a proposition is different from a statement in general because it sort of claims something to be either true or false in the world. This matters because all other types of statements will not really be considered when we are taking this analytical approach. So things like questions, commands, any type of any type of expression about how you feel. A lot of the analytical tools we'll be discussing today, they don't really work with those types of statements. So we're mostly looking at propositions. If we look at the examples on the right, we'll find a lot of propositions. For instance, all of the swans that I've ever seen were white, right? That statement can either be true or false, and that's why it's a proposition. Now, here you see two different types of arguments. The reason I put these two types of arguments in there is because legal arguments tend to be more similar to the second example than the first. So let's go through them. All the swans that I've ever seen were white, therefore all swans are probably white. This is the classic example of an inductive argument. And an inductive argument is sort of characterized by relying on probability, right? It doesn't say that this statement is definitely going to be true. It just provides you with good reasons to accept that there is a high probability that the conclusion will be true. Deductive arguments, on the other hand, rely mostly on certainty, right? And this is important because a lot of legal arguments that we'll be looking at throughout this course are of this kind, right? So they try to guarantee that the conclusion will be true. A second distinction that will not be as relevant for this course, but it might be relevant for other courses, is that inductive arguments tend to expand our knowledge of the world, whereas deductive arguments tend to test the knowledge that we already have about the world. To summarize, arguments are usually meant to remove doubt about a claim, whereas explanations are meant to help someone understand something. This distinction matters because we tend to use different analytical tools to assess whether something is a good argument or whether something is a good explanation. And for the most part, we'll look at how well they fulfill these purposes, right? So if an argument doesn't remove doubt about a certain claim, it's not a great argument. Similarly, if an explanation doesn't help you understand something, it's not going to be a good explanation. And if you want to test this, what you look for is whether there is actually something that's in dispute, right? So if you're reading through a judgment and both parties agree that something is the case, then it's probably not going to be very interesting for the sake of your analysis because it's not going to be very contentious. One last practical tip, if you're looking for the interesting bits in a judgment, is to look for indicators. And this is going to be important because it allows you to quickly distinguish between premise indicators and conclusion indicators. So you'll know whether a statement is meant to support, whether a proposition is meant to support another proposition, or whether that's the sort of final conclusion that you're supposed to draw from it. I have to say that this is not really a foolproof method, but at least when you're sort of skimming through a judgment for the first time, it does sometimes allow you to quickly identify where the premises and where the conclusions are located within a judgment. So I'd say use this tip with some caution. So something that makes the distinction between arguments and explanations a bit more difficult is that arguments sometimes include implicit premises. To make sense of what implicit premises are, we first have to look at the concepts of validity and soundness. So validity, the idea, the concept, what it prescribes is that if you accept the premises of an argument, then you must also accept the conclusions, right? So there should not be any logical possibility for you to accept the premises, but not the conclusion. When an argument is invalid, it does not actually guarantee that the conclusion will be true. So here I have three examples of arguments that sort of sound similar, but their forms are different. And the last one has an invalid argument form and therefore does not guarantee that the conclusion will be true. So you can have a look at this example yourself. I know it's confusing. If I read all of these arguments, it will probably not make a lot of sense, but I want you to think about the following. If you look at these examples, suppose that today would be a Thursday, right? If today would be a Thursday, we don't know whether that would be a free coffee day or not. I'm not going to say a lot more because I think validity is one of those concepts that you have to sort of think about. You have to look at an example. And then once you see what the problem is with this third argument, you'll understand what validity is. Because it's an online only course, I will not be able to answer your question. I just expect that you'll do your reading and then you'll figure it out. A closely related concept to validity is soundness, and soundness basically requires that all of the propositions should be true. Now, returning to this idea of implicit premises, if we're being charitable readers, we have to assume that the arguments that are presented by a court in a judgment are intended to be valid, in the sense that they are intended to guarantee their conclusion. So let's say that we are presented with an argument and that there is a logical step that's missing. It's up to us as charitable readers to uncover what that step is and to see whether that's the step that would actually be something that sort of needs to be discussed or whether that's something that could be assumed. Now, implicit premises are very common. They're not a bad thing, but suppose that you're reading a judgment that sort of assumes that you know that certain rules are already well established, right? That they are not contentious. Then if you are not aware of the fact that you're supposed to reconstruct an argument and sort of fill in those gaps yourself, you might come up with a very uncharitable reading that doesn't interpret the argument as strongly as it could have been interpreted. Then your commentary on that judgment is probably not going to be as strong. So before you start coming up with comments, coming up with sort of insufficiencies in the court's reasoning, it's really important that you uncover implicit premises. I know this was quite a lot, so let's do a brief recap. So propositions are essentially assertions about the world. When those assertions support other assertions about the world, we call them premises. And when a proposition enjoys a certain amount of support from another proposition, we call them conclusions. And together we would refer to them as arguments. I think the concept of validity is also a difficult concept. So essentially, whenever a collection of these propositions guarantees a certain outcome, we would call that a valid argument. And these implicit premises, they're essentially premises that are assumed not to be contentious, right? So an important distinction, if you are trying to ascertain what parts of a judgment are contentious and what parts of a judgment are not contentious, is whether you're looking at reasons that are being given or that the court is trying to help you make sense of what has happened up to this point in the judgment. Another interesting section in judgments is the issue section. And the issue section will usually be sort of a question that's put in a judgment in bold. And these issues, it could be one question, it could be multiple questions, but essentially a lot of them will have the same sort of formula where they try to take a specific legal rule and try to determine whether the conditions for that rule have been met in a specific because of a specific fact pattern. And that question will usually be answered with something that we will refer to as classificatory arguments. So this translation of taking very abstract rules and then looking at whether this specific fact pattern fulfills those conditions is going to be the core of any case, right? So the answer to the question that's ultimately presented by a court. What I want you to pay attention to is that these legal conditions and whether they've been met will often be accompanied with a lot of unclarity, right? So a lot of these rules, they'll contain words that are not immediately obvious. What does the word religion mean, for instance, or what does the word violence mean, and how do we use that in day-to-day practice? And that's why it's important to know that in the next section, there's sort of a distinction between different types of, well, we call this section rules, but different types of norms, because certain rules or certain norms will have a character that you could describe as definite, right? So a rule in a specific rule book that's sort of written down as an all or nothing command will be referred to as a rule from here on out. And whenever there is a rule that, for instance, says you have to try to eradicate all forms of inequality, that would be considered more of a principle. The reason this matters is because when a rule would be considered violated versus when a principle would be violated sort of differs, right? So because they are optimization commands, yes, you have to do your best to eradicate, I don't know, certain types of inequality, but within the limitations that exist for you as a state, right? So you have to make a genuine effort to accomplish a certain goal, but if there are obstacles, we realize that we don't live in an ideal world. When it comes to rules, on the other hand, you just have to follow those rules. And whenever rules are in conflict with each other, one of the rules will usually be considered invalid. Whereas with principles, they conflict with each other all the time. So whenever the court has sort of explained what the issue is, what they're going to be looking for, there'll usually be a section where the relevant principles will be mentioned, the relevant rules that will sort of support the interpretation of the court will be mentioned. But this will usually be quite a brief section. After the court has identified the rules that they will be using, comes the analysis section, and the analysis section is meant to clarify how the court will interpret certain key legal terms. An important thing for you to know is that these legal terms, they're always in development. They also mirror some of the societal debates that are going on. So whenever you read a legal rule that contains a specific word like religion, like violence, these are things that will often be in continuous development. So a judgment from, let's say, 2012 might not be as relevant today because we have, because science has developed, because our societal perception of certain norms has developed. So that really keeps the legal field alive, I would say. But nonetheless, an important thing to know is that a lot of these questions will be answered using doctrinal research, right? So the court will be confronted with a specific word that they want to interpret, and they'll often look at the rest of the legal system that they're in to figure out what meaning they could give to this word for the whole legal system to still make sense. So in order to sort of ensure this level of coherence, that whenever we mention the word religion, for instance, that it means the same across our legal system, there will be sort of a desire within the legal community to look for some sort of coherence. It doesn't always happen, but that's what's usually going on in the analysis section. So the application section is where the court will actually make its classificatory argument. So after having identified what all of those words mean, after having identified what all the facts were, the court will usually bring them together. Now, a key idea for you to be aware of whenever you're reading the application section is that the court will be very selective in, for instance, what facts it will choose to represent or what rules will actually be used in the application section based on a simple question: does it support a specific conclusion, right? So relevance is a concept in argumentation theory that basically asks, does this premise make the conclusion more or less probable if it was false? If falsifying the premise would affect how easily the conclusion would be accepted, then that's considered to be relevant. Now, an important thing to know here is that that's not a yes or no question. It's a matter of degree. And I created an example to sort of demonstrate this. So suppose that you were of the opinion that electric cars emit less CO2 over their lifetimes. Then we can present a couple of premises. You feel free to go over them by yourself. And then the question would be, okay, so which of these premises would you consider to be irrelevant or less relevant? If you go through the premises, the last two are indeed less relevant than the first few premises, but you can still make them relevant, right? So if you were to explain what the connection is to the actual conclusion, that would make them more relevant. This is going to be a concept that we will also get back to when we actually talk a little bit more about legal writing. But for now, just knowing that there has to be some sort of a direct link between the initial proposition that you're arguing for and the propositions that come afterwards, that conceptual link would be sufficient. The last section of a judgment is always a conclusion, and in essence, the court decides there what the outcome of a case should be. An important sort of caveat or something to pay attention to when you're reading conclusions is that conclusions come in different sort of styles, if you will, right? Some conclusions are meant to be directly enforceable, which means that they can have sort of a direct legal effect at the national level or at an international level. And other judgments are meant to be more declarative in the sense that, whenever you go to an international court, it could simply clarify to you how the rules are supposed to be interpreted, and then the court could give that interpretation to a national court to really make its own assessment, right? So whenever you're reading a judgment, please make sure to know what type of conclusion you're reading.